Thank you for those words. I'm going to talk to you today about my area being legal translation and the translator as an expert witness. And we're going to look at, first of all, what an expert witness is. Expert's a word that I really don't like because today being today, we have a lot of people who call themselves experts and most of them are self-appointed experts. But it's the term that the law uses, so we have to, that's one we have to go with. There are some principles that have been established in relation to expert witnesses and their evidence in court, and it's called the Makita Principle. And I'm going to talk to you about the application of the Makita Principle in a case called the Queen and Yang, which was a 2016 case of the West Australian Supreme Court. And I'm sure you'll forgive the parochialism, but this is, as far as I'm aware, one of the only cases that is in this country at least. And Perth, believe it or not, is in the same country as Melbourne, okay? So I do come from the same country as the rest of you, all right? It is, as far as I'm aware, the only case which has actually looked at translators as expert witnesses. So what is an expert witness? Well, the role of an expert is to assist the court in determining the issues in dispute. And to be able to do this, the court has to be able to assess the evidence that's been adduced, and that includes the independent expert's opinion. Now, generally opinion evidence like hearsay is excluded. Basically because opinions, as the saying goes, are like belly buttons, everybody's got one. Okay, so it's not reliable. But an independent expert's evidence is different. It's a carve-out, it's an exception. And the expert's responsibility is to provide the court with criteria to enable this opinion to be assessed. So, what this expert evidence allows the court to do is to draw inferences from observed and communicable data. And as I said, generally opinions are inadmissible because of their lack of reliability. Okay? But this assists the court in determining the facts, okay? Because the law generally draws a distinction between the facts and inferences based on facts. What can we say actually occurred based on the facts? And there's always overlap over this, but basically a witness's role is to state the facts. And then the judge or the jury, depending on if it's a criminal or a civil trial, is to draw inferences based on the facts. Now, in Western Australia, I'm not sure what's been said, but there's a very high-profile criminal case going on at the moment about who has become to be termed the Claremont serial killer. And the first 2 weeks of this trial, it's a judge-only trial, because there's just no way that a jury could not be prejudiced being in Western Australia. The first 2 weeks have been about what inferences can we draw on the facts based on this person's personality, his role, where he hung out, his previous criminal convictions, etc. So drawing inferences is a big part of the court's role. Now, when can expert evidence be admissible? Well, first of all, in terms of a doctor, may express his or her opinion about the probable cause of an illness. And this will become critical, particularly in medical negligence or criminal matters. Based on a qualified surgeon or a qualified medical doctor's expert evidence, a court may find that it was negligence that caused illness or death or incapacitation, etc. Similarly, a ballistics expert would be called to testify regarding the trajectory of a bullet. Now, a witness can say, yes, I saw I saw the victim being shot, but the ballistics expert would be called to say, well, would it be likely in these circumstances that the bullet could have travelled in the trajectory that it did to enable the death to occur? And this expert evidence, these inferences that an expert would draw, has to be based substantially on this person's or this expert's specialised knowledge. And this is codified, for example, in section 79, subsection 1 of the Evidence Act, which is a New South Wales Act, but this is replicated across the country. So if an expert has specialised knowledge based on his training, study experience, the rule against opinion evidence doesn't apply. There's always a qualifier. And that qualifier is that this evidence has to be relevant. Okay? Now, the court, it's within the court's discretion to refuse to admit this opinion evidence if it could be unfairly prejudicial to a party, misleading or confusing, or be an undue waste of the court's time. So what that means is that an expert has to understand, any expert witness that's called, has to understand that this report or the evidence that the expert is going to provide has to be within that expert's field of knowledge, and that the inferences that the expert is going to draw has to be based on this specialised knowledge. Now, expert evidence, as we've seen in this country, isn't foolproof. I say two words to people who question, Lindy Chamberlain. Okay? Right? Expert was called in the Lindy Chamberlain case. If anyone is not from Australia, this was a movie was made into a movie. Meryl Streep was the actress, about a baby called Azaria Chamberlain, who family was camping at Ayers Rock. In the middle of the night, dingo took the baby, and an expert witness was called in the original trial who said it's impossible for a dingo to carry a baby of 14 months old. Later on, that evidence was found to be wrong. So the point I'm trying to make is that the court will go to great lengths now to ensure that this expert evidence can be reasonably inferred based on this person's knowledge. So it doesn't fall into any one of these three categories. The other thing that's important to remember about expert witnesses is that the expert's evidence, just like the lawyers, just like the interpreters now, first duty is to the court. Okay? So experts can't be coached or be told to adduce evidence so that a certain outcome will result. So experts need to be sought with great care, and that his or her independence cannot be perceived to be compromised in any way. The Makita Principle. And for those of you who know power tools, this is in fact Makita, the company that makes the power tools. Okay, this was a civil case in the New South Wales Supreme Court concerning the admissibility of expert evidence. Now, this was a case about a Miss Sproul's who was an employee of Makita, and she sued her employer for negligence after she fell down the stairs at her workplace. And she was awarded substantial damages, and the court relied on expert evidence relating to the tread on the stairs in this workplace. And the expert stated that the tread of the stairs in Sproul's workplace was slippery, and as a result, this would have caused her to slip and fall and therefore injure herself. And obviously Makita wanted this evidence out because it would have been prejudicial to them. But the issues about experts and the evidence was endorsed, that experts must be able to furnish the trier of fact, i.e. the court, with enough criteria to enable evaluation of the validity of the expert's conclusions. And in order to do this expert's evidence or opinion has to be within his or her field of specialised knowledge, based on study experience, and have to be based on a proper foundation of the facts. And at the end of the day, the court has to be able to say, well, we can draw the conclusions about guilt or otherwise, or liability or otherwise, reasonably based on this expert's specialised knowledge. So as I've said, this has to be clearly related to the facts, and the assumptions upon which the expert is drawing his evidence must be based on knowledge, experience, etc. And therefore, when briefing an expert on evidence, if he or she is called to give evidence, the expert has to understand this, okay? Because if not, that evidence will be rejected. So how does this apply to translators? Well, let's have a look at the Queen and Yang. Now, this was a criminal prosecution of an offender, a Mr. Yang, who was charged with importing crystal methamphetamine into Australia under the Commonwealth Criminal Code, which is an offence under the Commonwealth Criminal Code. And because it occurred in Western Australia, the case was tried in the West Australian Supreme Court. The relevant facts were that Mr. Yang, he was introduced to this enterprise through his friend, a certain Zhong. And Zhong said to Yang, look, you have to deliver a piece of luggage from China to Australia. And he'd done this before, from Brazil to Thailand, not in time, recently, prior to this enterprise. And before boarding this flight to Australia to carry this piece of luggage, he received all his instructions from a certain Miss Bello, who purportedly operated out of Russia. And the case was presented by him. Look, all I had to do was take this piece of luggage. I didn't know what was in it. I was just doing a job. Lo and behold, he gets to customs in Perth, and surprise, surprise, there's crystal meth in there. Hmm? So the Crown alleged that Mr. Yang knew that exactly what was in that luggage, and Mr. Yang said, no, I knew nothing about it. So how could the Crown prove this? Well, it had to draw their conclusion from text communications between Yang and Zhong, and as well based on communications with this Bello, who supposedly was operating an apparel business and who was the one who engaged the offender in the first place. So based on these messages, the issue for the court was, well, these messages weren't in English, they were in Korean. And the Crown therefore engaged a translator to translate these messages. And I use the word deliberately because there was the accreditation system at the time. So the Crown's case more or less rested upon these translations of these messages, in which they could assess the guilt or assess the accused's guilt based on his knowledge arising out of these messages. But the issue was, well, in drawing inferences out of these messages, questions were raised about the translation. Because at the end of the day, the messages were required to prove one of two things. that the offender knew the accused knew the luggage was in there and that he was consciously importing it, and the likelihood. And if the Crown could prove either one of these two things, Mr. Yang would have been found guilty. Now, the issue about the translations were that they were in what's known as cacao talk, social language, messages Natasha would know. Okay? And the question arose as to the translator regarding his reliability and certain inconsistencies which the defence alleged were in the translations. So Justice Fianacca went back to the rules. He said, well, a translator has to translate accurately in accordance with 5.1 of it, and I'm pleased he went to the Aussic Code of Ethics, without distortion or omission and preserving the content and intent of the source message. So the question was whether the translator actually did this. Now, Justice Fianacca said yes, he's approached this task impartially, but under cross-examination from the defence, he admitted that yes, other translations were open. However, overall the translations were accurate. But there were deficiencies, and the translator conceded them. Because at times there were a lack of notes, particularly in relation to a laughing emoticon, the ha. Now, ha in this cacao talk, and Natasha, correct me if I'm wrong, could be ha, yeah, that's very funny, or ha, this is ironic. Certain parts of the message were disregarded. Not all these laughing emoticons were translated, and certain expressive characteristics of this social media language were omitted. And furthermore, the translator in his notes actually expressed an opinion about the conclusion that could be drawn from a message. In other words, this has to be an ironic statement. This isn't true. So there was some caution by Fianacca. Many messages, as he said, contain laughter, particularly in relation to the discussion of the nature of the enterprise. And at the time, there were some, in the messages, there were remarks about whether illicit drugs were involved. Ha ha ha, ironic laughter. So it didn't go to his impartiality, but the accuracy of some of the translations. And more specifically, in such situations, it's not for the role of the interpreter or the translator to express an opinion about the state of mind of the accused or the witness. Okay? And as I said, in the translations, in the translator's notes, the translator actually drew some inferences about what was actually being conveyed rather than actually translating what was being conveyed. Luckily for this translator, the evidence was still admissible. But there was a danger here that this evidence, upon which the Crown's case rested, could have been excluded. And if that evidence had been excluded, the Crown's case would have fallen away. And the accused would have walked free, with the potential for a retrial. So what am I trying to say at the end of the day? I think, particularly in terms of the context of this conference, we need to be aware about, all need to have an awareness about what our translations could be used for, particularly in a legal context, and the ramifications. Right? The consequences for the administration of justice. Okay, now in an era where there are lots of pressures on the court's time, the court doesn't like to have its time wasted, and wearing my taxpayer's hat, I don't like the idea of retrials because it costs more money, it takes up more time. Okay, so we need more translators, need to be properly trained and aware. And I think this translator here, obviously he approached the task probably with the best of his ability, but might not have been aware that if he'd probably not as done a good a job, less accurate, or expressed more opinions, or omitted more detail, the evidence could have been omitted, and therefore that has consequences for the administration of justice. Also, judges, legal practitioners and all participants in the justice system need to be aware of the role of expert witnesses, particularly in relation to translators and the implications of particularly mistranslations and translators not being properly briefed or aware of their role in adducing evidence in court. Thank you.